Good evening. This is Laws 12062 Alternative Dispute Resolution. It's week 3, and this week we're dealing with the specific topic of negotiation. I'm very pleased to see that most people have now formed their groups for the first assessment piece. I hope and trust that by now you're starting to give some thought to the specific dispute that you would wish to mediate or conciliate. You should probably look at creating some scenarios and providing that to the people that are working with you in your group so that they can choose a part to play, or you can assign a part for them. It's not just a matter of determining what the parameters of the dispute are. It's also a matter of giving some guidance as to how you would like the players to play their part. Or indeed, it may be that you ask them to simply adopt a view and it'll be a surprise to you. I think that the more that you can give freedom to your participants to play their part in a certain way as they see fit, the better, because it will then be more of a surprise to you and it will better test your skills in mediation or conciliation. So hopefully that's all happening now, and I'd urge you not to leave it till the last moment, of course, but enjoy the process. If you've created your scenario, if you've got your groups organised, if you've worked out the technology, it means that you can then perhaps think about what you're reading, think about what you're studying, and what we're discussing in these Zoom sessions a little more critically, applying it directly to the scenario that you've got in mind for yourself. Now, as I mentioned in week 1, I'm really not interested in a situation where you repeat to me things which are in the textbook. This is much more a course involved in the process of doing rather than actually simply theoretically knowing. So that's the emphasis for the course that we're doing at the moment. All right, now, are there any questions? I'll just put on gallery view for a moment so I can see who's there. We've got lots of people. That's good. You can probably all see each other at this stage. And if you do have any questions, please join in using the chat facility at the bottom or by asking the question, and you can do that live as well.
John, can I just clarify? I've only just been able to get on because the Zoom session that you sent through has only just appeared on my computer. Is that normal for it to run so late, or? Yes, there are times where I won't be on time. So I posted the link in uCrew at 6:33, and I usually go into Moodle first, and that would have been a minute or two earlier. So it wasn't right on 6:30. Sometimes you may need to refresh your screen. So if you're sitting there waiting and nothing happens, maybe just try the refresh button as well. So my apologies. Thanks. No, it's okay. Thank you. All right, thanks, Erin. Okay, any other questions? All right, let's start. I want to talk about, I suppose, a basic concept, and that is the concept of negotiation as opposed to something else. The something else being the adversarial system of litigation. Now, in the 70s when I studied, we didn't have ADR. It just didn't exist. It wasn't a subject. It wasn't talked about. It really wasn't in any way offered as an alternative through the litigation system. We were simply taught about how to sue, how to defend, and so on through the court system. So ADR is a very new process in that regard. And it does provide parties with an opportunity to do a number of things, and very importantly, one of them is to take control of the process for themselves. So that is something which needs to be emphasised, I think, that having control of the litigation for the parties helps them to create more options and gives them that feeling of belonging in terms of the litigation. Now, you might say, well, that's a bit odd because litigation is all about the parties. But in my experience, litigation can actually take the process away from the parties so that they feel like they're following along rather than leading the process. And in the process of following along, they don't necessarily understand the procedures, the wordings, the timing, and that's not a good thing.
in terms of being a lawyer representing the party. So things are changing. In civil disputes, we're seeing a lot more ADR. We're also seeing it in criminal disputes. That's been legitimised through the introduction of case conferencing, which is something that I should urge you to consider and read about. That's case conferencing, which was created through the Moynihan reforms. In a way, and I'm just speaking now about criminal litigation, we have always had the opportunity to negotiate, but it wasn't formally authorised in the same way that case conferencing is authorised now. So the point is that litigation has changed dramatically, both in civil and criminal, and now most jurisdictions require clients and lawyers representing those clients to genuinely attempt to dispute resolution procedures prior to trial. So it's fundamental and it's a recognised part of the process. So litigation can take the dispute away from the parties, as I mentioned before, and it can also mean that we are arguing about people's position rather than their interest. And you'll hear me talking about this distinction between interest and position a lot during this course. So an example of an interest would be in an industrial dispute. The applicant employee may be looking for recognition for a job well done, but the litigation may be framed in terms of a pay rise, pay dispute. So the pay position or the pay rise may be the position which is adopted, but the real interest may be the recognition, and I suppose the pay would go with that as well. Now, in his book, Spencer talks about the fundamentals of negotiation and refers to Anstey in that regard, says that there are 7 attributes to negotiation. All right, so you've read all this, but I just want to tie it in a bit and get you thinking a little critically about what these things mean. Bearing in mind, of course, that there will be no question on the take-home examination which says, please describe the 7 attributes of negotiation. Everything about the assessment in this course will have a practical aspect to it. There'll be no theoretical questions. So when you read these things, you've got to ask yourself this question: how am I going to apply this in practice? How am I going to use this as a lawyer in a practical sense, both after the course is finished and more particularly while you're doing your take-home examination? Okay, so in his book, there's a reference to Anstey by Spencer. A negotiation involves more than one party, involves a joint agreement on the outcome, usually requires the movement of the parties' position and interests. Okay? Given that I'm emphasising the importance and the difference between position and interest, I want you to think about that. Usually empowers its users by providing self-determination. Well, we talked about that as one of the basic advantages of ADR as opposed to litigation. Is non-interventionary? Not sure if I agree with that one. Is often less expensive than other forms of dispute resolution. Well, that's probably right, bearing in mind that negotiation is a very free and open way of dealing with a dispute resolution, and it allows the parties to control the process and the outcome. Well, I definitely agree with that. Now, in his book, Spencer then goes on and talks about a number of advantages in relation to negotiation. So one of the advantages is, and this is the first one, I think one of the advantages that is written down, the parties are in the best position to assess the impact of any proposed solution. Okay, so that's one of the advantages of negotiation. And we can tie that back to attribute number 4, which is that negotiation empowers its users by providing self-determination. Another attribute is that parties own the process and can define its terms in any way they choose, which is number 7, allowing the parties to control the process and the outcome. The next advantage, parties create their own solution and therefore are more committed to ensuring the agreed solution or settlement works, which is attribute number 2. It involves the joint agreement on the outcome. The next advantage is stated as being parties have a chance of getting what they want, that is, not all or nothing, as may be the case in litigation. So that's an important one. It's not tied to a particular attribute, but it's a very important advantage of negotiation. Bearing in mind that most matters do settle by negotiation, so why not try it sooner rather than later, after you've incurred a huge amount of expense, emotional drain, and of course legal fees in many instances. And then finally, the advantage of negotiation, if it's not resolved, it gives the parties an opportunity to narrow the issues in dispute, which again comes back to attribute number 7, having some control over the process. And I'm just going to stop there and emphasize that if a matter isn't going to resolve, so if this happens in your assessment piece, then at least give some thought to ensuring that the parties have identified the true issues, and maybe give some thought to asking the parties to assist you in framing a way of, and this is in conciliation, of framing a way to allow for the ongoing progress of the matter if it goes to litigation. We'll talk more about that in the conciliation process. All right, so let's now talk about the negotiation process. Negotiation is most successful when parties do a number of things. I'm going to ask for some help here. If you're going to be giving some advice to your client during the course of the take-home examination as to some of the things that should be done in terms of a negotiation, either before or during or after the negotiation process, what are the things that the parties should be thinking about in preparation for their negotiation? Can you think of some things that you're going to advise your client are important for consideration? Okay, so what each party wants out of the negotiation. Thanks, Tony. Clarify the interests. What are the interests? Yes. So I like that thought. So we're asking parties to think about the end result, and we're asking them to do it critically. What do you really want to achieve out of this, and what is in your best interest here? Sometimes see what are the main issues, see if they're the same. Sometimes what the parties say they want is not necessarily in their best interest. So you may need to, Jenny's got it right, you may need to ask, are their expectations realistic? Why? I like that word why. Thank you, Sarah. Why do they want to achieve what they're looking to achieve? That's really important. That question, any question that starts with why is going to start to elicit something in terms of the party's interest, which is what we're trying to achieve. Okay, so I like all those answers. Anthony, is there any wriggle room? Catherine, what is their BATNA, their best alternative to a negotiated agreement? And make them think about what they want to do. So thank you for those responses. Okay, so here's a list of things that I've put together which I think are important. And that is, number 1, make sure that they understand that there are some preparatory steps which should be undertaken before we commence a negotiation. One of them is to determine the mode of the negotiation. So if you're speaking with a client who wants some advice, wants you to assist, you might want to talk about how the negotiation shall take place. Are there any examples? Can anyone give me some examples of different modes of negotiation? Teleconference, conciliation. Okay, so these are different modes. Arbitration, enterprise bargaining. Yep. And these are really quite specific. If a negotiator senses one party doesn't want to be there, would it be prudent to ascertain why? Yes. John says face-to-face. I like that. So there are different ways that we can negotiate, aren't there? Teleconference, face-to-face, involving third parties or not involving third parties, determining it through a formal process, which is still negotiation in the form of some sort of arbitration or enterprise bargain or conciliation. So you want to speak to your client about that and give some advice and perhaps tailor the advice. So the point is that the first thing for the parties to think about is, how are we going to do this? Now, once we get to the negotiation stage and we're ready to negotiate, if I could just say this, make sure that you establish there is an authority to bind. Now, what I mean by that is that if, for example, you're giving some advice to an individual in relation to a neighbourhood dispute, you might want to ask the question whether that individual is the sole owner of the property, because he or she may be married, or it may be an investment property and there's another silent partner. So you might think that you go into the negotiation and the person that you're representing has full authority to bind, but that may not be the case, and it's something that should be considered from the outset. Likewise, of course, it works the other way. You may be negotiating with another side, thinking that party has authority to bind, only to find that when you've concluded, or you think you've concluded the negotiation, that party says, well, I'll have to, of course, run this by my partner before I can give you a final response. That's the sort of thing that you want to sort out from the start. Okay, so we've gone through the process of determining what is the appropriate way to negotiate. We've now established that the parties have the authority to bind themselves during this negotiation, and we're into the negotiation proper. So what are the first things that we want to think about when we're in the process of negotiating or assisting a party in the negotiation? All right, are there any thoughts? What was the prior relationship? I like that. That's good. Get some background to it. Are there any other thoughts? What are the first things that we want to ask the parties to do? Ask them what they want. Yes, what do you want? That might elicit a positional response, but it's perfectly legitimate question. So get an idea of what the end game is. So Siobhan says, think about what was in the past. John says, think about what's at the end. Now, get some ground rules. Obtain the parties' consensus. Issues regarding confidentiality. Thank you, Audrey. Thank you, Brad. Why are you here? Thank you, Sarah. I can see Sarah likes that word question starting with why, which is a good one. Okay, so they're all really important issues to consider. I think what you then need to do, and I've used the word issue, is identify the issues of concern. During the course of a negotiation, what you want to try to do, if you're, for example, involved as the mediator, or if you're representing one of the parties, is try to ensure that once we start the discussion proper, we're really talking about all of the key issues, the important issues, and we don't get sidetracked halfway during the process of negotiation. So, for example, in your mediation, you want to really make sure that you've identified and had an agreement between the parties as to what the issues are. Now, typically there might be, say, 2, 3, 4, 5 issues of concern. Before you start the negotiation properly, make sure that those issues have been properly identified. Make sure that we're arguing about the same thing. What you don't want to do is get 30 minutes into your mediation session and then find that one of the parties says, yes, but my real concern is the fact that your dog keeps barking. That's what really bugs me the most. That's the sort of thing that you want to draw out from the parties if you're the mediator right from the start. Sarah says make an agenda. That's right. Let every person have their say before speaking. So give them a chance to say things if you're the mediator. And of course, tonight I'm really bouncing between you as the advisor, which is more the role you'll be taking for the take-home exam, as opposed to you, the mediator or conciliator, which is the first assessment piece. Brad says, try and find some common ground, ask how the problem started. These are all good points. Okay, so we want to have an agenda, I think is, and identify the issues. The agenda will flow from the identification of the issues. Okay, so we now know what we're arguing about. If you're an advisor, or if you're the mediator or conciliator, what's the next thing that you want to start asking people? What do you want to then do? You've identified the issues, you've given them their say, get the parties talking, great. And that can be difficult in your mediation session. You might find that one of the parties sits there saying very little, arms crossed, apparently disinterested, so you need to get them to draw it out. Find out how the parties would like to proceed, says Catherine. Yep. What is their solution? Are there limits in time for a solution to be reached? So consider some alternatives, generate some options, make an opening statement. So we're getting a wide range of different answers there. And I can't say that they're wrong, they're all good. Tell them a joke to make them relax, says Tony. Advise them of the costs that may be involved if no resolution is reached today. Thank you, Jenny, which is really looking at, say, the best alternative or the worst alternative to a negotiated agreement. And Audrey says, get some points down. Okay, so I think what you want to do is identify the issues, do that after everyone has had their say, generate an agenda, and then start to maybe consider some options. So break the issues down, agree on at least one. I like that. That's really important, because if you can secure some point of agreement, people will then start to trust what you're saying, and it gives you an opportunity to move on from there from a solid base. Brad says, make sure they're comfortable in the room, make sure the positioning's right. So don't ignore those practical issues. That's great. All right. So I agree with all of those. Annalise says, yep, agree on at least one thing, even if it's a small matter, it's a step forward, and that's important. Okay, so now we're sitting in a comfortable area, we're identifying the issues, we're developing options, we're considering alternatives. Now, here's where in your assessment you need to make a basic decision, and that is, if it's a mediation session, a pure mediation session, the mediator won't be generating options or considering alternatives, and certainly won't be offering any opinions. In a conciliation, you are allowed to do those sorts of things. So, for example, as a member at QCAT, I will sometimes convene mediations, which means I'm going to be far less interventionist, as opposed to a conciliation or compulsory conference, where in that role, I'm expected to assist the parties in generating options and consider alternatives, and perhaps in private session to provide some thoughts as to what might happen if the matter goes to a tribunal hearing. Okay, so considering options is one way to do it. Then we really start the process of negotiation proper. So this is where the parties are negotiating in good faith, working towards an agreement. Once we've had that agreement, we then document it and we act upon it, or parties act upon it, to conclude all matters of mutual concern. So they're the processes in kind of an abstract way, which will ultimately lead to the most successful outcome in a negotiation. What you need to do is collect your thoughts and be prepared to use them when you're the ADR practitioner, and be prepared to advise parties as to what they need to do to prepare for the mediation and what they can expect during the mediation or conciliation conference, as the case may be, so that they can get the most out of it. All right. Now, thank you for your input so far. I'll just put everyone on gallery view so you can hide if you want to. All right. We've still got everyone there. That's good. Okay. If there are any questions, if you want to come in live, just let me know.
I have a question.
Yes.
How you said before, you go through it, you negotiate, then you reach a consensus and agreement, it's written up. In reality, though, is it really, does it happen all in one negotiation, or is it does take 2 or 3 sessions?
That's a really good question, Audrey. Thank you. Typically in a mediation or conciliation conference, you'll be allocated a period of time. 3 hours is probably a fairly common period of time, and the hope, expectation is that it would be resolved during that period of time. Occasionally, you'll have a second session. So I've had mediation sessions, for example, where I've got 25 people on one side and maybe 3 or 4 on the other side in a dispute situation. And that can be difficult because of the number of people involved to have the matter resolved in one session. So you might go into a second 3-hour session on a different day in that situation. But generally speaking, if you've got the parties attending a mediation or conciliation, you'd hope that you would have it resolved, or at least the issues determined at the end of that 3-hour session. But thank you for that question. Is that a situation where you'd have a spokesman? Yes, Aaron. Ideally, you'd have a spokesperson or a group of spokespeople. So in that one that I'm referring to, without breaching any confidences about what it was about, I think I asked for 3 people to represent the main group. Minutes recorded, says Forbes. Generally not. When you say minutes, I guess you're referring to things that were said during the mediation or conciliation conference. That would not be recorded for future use. Generally speaking, I'll destroy my notes afterwards. And really the whole process is meant to be confidential. There is an exception, of course, and that is if there is an agreement which is struck, then that becomes something which will endure into the future. So, but thank you for that question. Are there any other questions? All right. Okay, let's talk about the role of lawyers. I'll just go off. Are there times where someone is being so ridiculous and wasting everyone's time? Yes, that's a really good question, Jenny. And I'd be interested to get people's responses to that. What are you going to do when they want to make 0 offer of settlement, says Melissa? You're going to have to ask yourself this question. In your mediation session, if you get one party that is just absolutely stubborn from the outset, what are you going to do to try and get them to engage? Can anyone think of any ideas of what you might do if you're dealing with an absolutely stubborn party, not willing to engage at all? Ask them.
I've actually had experience in that.
What was that?
I've had experience in that. I used to run unfair dismissals and a conciliation, and then the other party would come and they wouldn't want to listen, and you'd have to say to them, well,
Trace the letter.
It's going to go to arbitration and you're going to have to go and get legal advice now, and there's going to be more time, more cost involved. The case we've got's pretty strong, and you just have to suggest those points, and then you'd have a break and then see if they would settle or, make an offer.
Very good. Okay, thank you, Audrey. And you can probably see there on the screen, I'm not sure does it come through on your screen or is it just mine? Some of the responses while you were talking there, Audrey, which are very good. Ask them, advise them what the alternatives are, find out why they're so negative, says Annalie, because they've come to the mediation in the first place. Ask them what happens, says Sarah, if the mediation fails. If one party has misrepresented evidence, how do you deal with that? Melissa says, yeah, increased cost of advising on poor prospects on their part if the matter proceeds to trial. So one of the common themes there, I think, is asking them why are they here? What do you hope to achieve? You've made the effort to be here. Let's make the most of it, and let's consider what's going to happen if we can't get this resolved. So some really good responses there. Confirm someone forced to attend by summons, says John. Yes, sometimes conferences are compulsory, but I'm not sure that I would ever see a situation where someone must be compelled to attend by summons. There would be other consequences, but I don't think a summons. Jenny says, does it ever get violent? Yeah, you have to be careful. Melissa says, I've known some. Let's think about that. What would you do if it got to be violent? Are there any suggestions? Some people think they can make the proceedings go away by ignoring them.
John, okay. I think if someone became violent, I think you'd nearly need to separate anyone and just be one-on-one with the person who's attempting to be violent to try and quieten them.
Yes, okay. I think that's good. So maybe you could go into a shuttle mediation. Audrey says call security. John says call security. Catherine says split the parties. Rebecca says end the mediation. I prefer we didn't do that, but yep, in certain circumstances we have to. So thank you, Rebecca. Audrey says get out of the room. Stop the meeting, says Tony. So a few answers there. You need to think about that. And he says try to diffuse the situation, but not a big person. I put myself at risk. So yeah, just be careful about your personal security as well. I mentioned a shuttle mediation. That's where we have a situation where the parties are physically separated and the mediator will go between the parties rather than everyone being in the same room. So don't respond, let them run out of steam. That's a good way of doing it too. Okay, I like all those responses. Okay, I'll just go off to speaker view. I just want to talk about the role of lawyers. There is, I think, a dynamic sometimes that lawyers can be a negative. My personal view is that I like having lawyers involved in a mediation session or a negotiation session. Can anyone see any reason why it would be good to have a lawyer? We'll deal with the positives first. Why would it be good to have a lawyer involved in the negotiation? Think about the BATNA, know the legal issues, yes. So I like the word issue there, and BATNA, we're thinking about the alternatives if it doesn't settle, which means that the lawyers are helping them to stay focused, says Erin. The lawyers help them to understand their interests and not necessarily their position. A person will trust their lawyer. They know the likely court outcomes, so they can provide some realistic alternatives. They can create some realism to the situation. So I like all those. Objective, yes. Lawyers are going to be objective, removes the personal, they're not emotional about the issues, etc. Some really good responses there. So I guess in your mediation session, I wonder if anyone's going to be brave enough to have the parties come in apparently represented by a lawyer, and you have to deal with that situation where the other side says, no, I don't want them to be represented by a lawyer. Well, that'd be an interesting thing. A lawyer acts as a legal representative. The costs of a lawyer can provide an unfair advantage. All right, so we're getting on to the disadvantages now. John's identified one. Barristers are a different proposition, says Erin. So now let's talk about the negatives of having lawyers involved. John has identified one. The cost will be higher if a lawyer is present, and it can give an unfair advantage to the other side. It adds more formality. Any disadvantages of having lawyers involved in the negotiation process? Tony says you can object under Section 596 of Fair Work Act in arbitration. Jenny says, I don't think I'd like to mediate with the other side having a lawyer present. Can be seen as a bully tactic, says Siobhan. Parties will feel more nervous and less likely to speak, says Catherine, if there's a lawyer there. Erin agrees. Sometimes they can be inadvertently get your client to admit things. Yes, adversarial, so it can digress the wrong way, and both or neither would have to be represented. Well, says Annalie, I'm not sure or that's a question. Sometimes it's perfectly legitimate to, and very common actually, to have one party represented by a lawyer and the other is not. But we'll need to think about what will happen in those circumstances. John says the lawyer could try to dominate the process. Brad says they'll start to speak with lawyer speak, which will try to baffle the other side. And Jenny says it might defeat the purpose of mediating by having lawyers there. All right, so a few different opinions there as to the pros and cons of having a lawyer. So think about that, because you'll probably need to give some advice in your take-home examination about whether you as the advisor should be present, and if so, what are the advantages, what are the disadvantages? Catherine says barristers have been on both sides in mediation she's been involved in, and the barristers do all the talking. That's true sometimes, but as a solicitor in mediation sessions, I must say that I do get involved, but that's probably just me. It's more in line with the court situation, says Erin. Rebecca says, can you ask the lawyer not to speak on the client's behalf? Yes, you might set that as a ground rule. Is it common, says Siobhan, to have lawyers involved? I think that was a question. Yes, depends on the dispute, says Forbes, absolutely. And Jenny says, it defeats the purpose. Noah agrees with that as well. It creates a difficulty in communication between the parties. So if you're the mediator or conciliator, you've really got to give some thought to setting some ground rules in terms of how the lawyers to involve and interact with parties. And you want to make sure that the lawyers do assist the process rather than get in the way of the process. Okay, so some really good responses there. And again, you're not going to get a question on the exam, tell me the advantages and disadvantages of lawyers being involved in mediation. You might have got a question like that from me in Introduction to Law, but you're not going to get a question like that in ADR. I'm sure you'll understand. All right, so you've got to think about what's going to happen. You've got to be proactive in terms of the advice that you give to the client, and think about what might happen in your mediation session if a lawyer turns up. All right. So one thing that wasn't mentioned is something that I will come back to regularly, and that is the question, at least, I'm not saying it's definite, but by having lawyers involved, I just question, are we assisting the parties to take away this dispute from themselves and they lose ownership of that dispute? So owning the dispute, I think, is a really important thing for clients. And to be fair, some answers did indicate that as well. All right, we've just about run out of time. In the material, there's a lot of good commentary about the models of negotiation: adversarial, integrative, distributive, principled, the star of the show, principled. Just briefly, my take on them: adversarial, a win-lose situation, an extension of what happens when lawyers are involved. It tends to be linear. So in adversarial, it tends to be, and this is in the graph in Spencer, we have the two positions and we have the area in the middle, which is the area where the matter might be resolved, but it's very positional based adversarial negotiation. So there's offer and counter offer until you finally meet in that area of commonality. It's quite competitive. It's not particularly creative adversarial negotiation, and it can provide advantage to the party with greatest resources. And what it does is it may result in the parties failing to achieve something which is in their interest. So that's why I'm not so keen on adversarial negotiation. There's a really good example used by Fisher and Urey in their book Getting to Yes, and it's the orange story. Has anyone come across the orange story yet? And I know you've been very patient with me, but I want to run this by you. Okay, so in this book Getting to Yes, the authors say we have a dispute, we have a problem. We've got two sisters. We have one orange and both sisters want that orange, but they want the entire orange. What can we do? So there was only one orange available. It was cut in half to satisfy them, and they got half each. Now, can you think of any other solutions? Think about their interest and not necessarily their position. Their position is, I want the orange. And the other sister says, my position is, I want the orange. How are we going to draw out their interests? Offer something else, offer an alternative. One might just want the peel and the other the juice. Spot on, Erin, that's it. Why do they want it? Thank you, Audrey. Would you like an apple? Squeeze it into orange juice. Very good. Okay, so Erin, that's what I was getting at. One might want the juice and the other might want the peel. Forbes says offer to sell one half to the other. So in that situation, neither of them were satisfied with the end result because the first sister squeezed her half of the orange for the juice and threw away the peel. The other sister grated the peel from her half to use in the cake and threw the rest of the way. So neither was satisfied and neither really truly had their interests met. So I guess we keep that in mind, the orange story, as a good example of where the obvious solution is not really the best solution. And that's what adversarial negotiation is all about. We have one orange, people are bidding against each other to get that orange. We're not really thinking about the bigger picture. Integrative negotiation takes it one step further level, and that's where parties can provide something relatively cheaply but of considerable value to the other party. So in integrative negotiation, what we're really doing is increasing the pool of resources available to be distributed. It's a way of value adding to the negotiation. So it's kind of taking the adversarial approach, but going off on a tangent to say, well, instead of just splitting what we have here, what if we think about another way of doing things and we add in another dimension? It's really cheap for me as the manufacturer to provide you with this, and as the consumer, that's of great value to you. So you're value adding in that type of situation. That's integrative. Distributive negotiation, that's similar to adversarial in that we're really talking about a zero-sum transaction. It's talking about a win-lose result. And the premise is that we have one orange, we don't have any more, and it's got to be distributed between the parties. And if we're talking about a percentage, if one party loses 5%, then the other party gains 5%. So distributive negotiation is all about the concept of a fixed pool to be distributed and one party getting a share and the other party getting the balance. So it's not great negotiation, but it's very common. I mean, that's what you'll mostly see in the way lawyers traditionally have always negotiated. It's always distributive negotiation or adversarial negotiation. So as I said, the star of the show is principled negotiation. Think juror number 8 out of 12 angry men, and we're starting to think about principled negotiations. And it all comes down to the fact that people typically argue from their positions rather than their interests. So if you ask, what do you want? The party, there's nothing wrong with it, but the party will probably respond by giving you a positional response. If you ask, why do you want this? You're starting to inquire about the party's interests, and I think that's important. And John says, 12 Angry Men is worth watching even if you're not doing ADR. Yes, it's a great movie, says Jenny. And she changed her mind. Oh, that's good, Jenny. All right. So you need to practice your skills in transitioning parties from positional-based to interest-based discussions. And that's going to be a real test for you during the course of your mediation, because typically parties will start out from a positional perspective, and you need to practice your skills in transitioning those parties from the positional to the interest-based. Think about how you're going to do that. All right, so how are you going to do it? Well, You can generate options. You can assist them in generating options. Brainstorming. You can think about asking the parties to consider the matter from the other's perspective. And we've talked about BATNA, the best alternative to a negotiated agreement, and WATNA. And I'll leave you to read the rest of the chapter yourself, dealing with legitimacy, communication, relationship, looking to establish longer-term goals, and separating people from the problem. Okay. All right, so everyone's still here and most people are awake. That's great. All right, I'll wrap it up now. Are there any questions before we go? All right. Well, thank you very much for listening. And we'll speak to you during the week through UCrew and of course next week in Zoom.